Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you've Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyina. Uya matinyina. Uya matinyina. Oh, uya matinyina. Yeah. So uya matinyina. Uya matinyina. Yeah. Uya matinyina. Oh, uya matinyina. Say, I call you Jireh. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. Will you make one cover? What to say?
Once again, my name is 𝗖𝗢𝗠𝗠𝗨𝗡𝗜𝗧𝗬, and thank you very much for being here. The community and the law is airborne. Skilled workers and visa applications for child dependent. How are you going to avoid the trap of sole responsibility? That is going to be the discussion we're going to have this afternoon. So tell somebody to tell somebody to tell them that we are live on there. We are live on BWTV at BWF Solicitors Facebook, BWF Solicitors YouTube, BWTV Facebook, BWTV WhatsApp, and all the other platforms. Once again, welcome to the community and the law, brought to you by BWF Solicitors in the UK and of course all over the world. We will be having the pleasure of having the discussion, answering your questions, and also meeting and sharing ideas. If you're ready, let's get into it.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you, and to have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208-493-7345. Or you can send a text 07950-422-780. It's The Community and the Law. My name is 𝗖𝗢𝗠𝗠𝗨𝗡𝗜𝗧𝗬, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, and I'm so glad to have you around for this afternoon's edition of The Community and the Law, brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are here and we're going to have a very lively discussion this afternoon. And I know it bothers on so many people's confusion as to what the Home Office mean when they talk about sole responsibility, and also how we meet that threshold to make sure that when we're making any application for our children to join us here in the UK, we'll do it right, and they don't, as somebody would say, corner us with all those intricacies that will make our applications fail. My name is 𝗖𝗢𝗠𝗠𝗨𝗡𝗜𝗧𝗬, and I'm delighted to be your host this afternoon, and also delighted to have the privilege of asking you all to join me to say thank you to BWF Solicitors, the law firm that understands our language, understands our situation, and has the ability and the strategies to make sure that we do things right, especially when it comes to our immigration matters here in the UK. This afternoon, I'm also again excited and privileged to have the senior partner of BWF Solicitors as my resource person and guest for the discussion. Mr. Bernard Osu has over 30 years of legal practice and experience here in the UK, and he has taken it upon himself to be there as a reference point for everything legal, especially when it comes to immigration matters. So, on your behalf, let's go over to his desk and say good afternoon and thank you for joining us. Agaba, good afternoon.
Good afternoon, Kwaku.
Thank you for joining us.
And thank you for inviting me.
Right. On behalf of everybody, we want to say we're so privileged to have you. And I know that people are going to get, some of you are going to get this recorded. Some of you are going to pick your pens and papers and your notebooks, and you're going to make a lot of notes. And of course, our friends in the legal fraternity, listen, knowledge is good. So let's learn from this one as well. Well, let's pick up some updates for the week. And there's a client who is very happy and excited about BWF Solicitors. Nina says, I contacted BWF Solicitors for legal support for spousal visa as first application was denied. Lawyer Charles Asma gave legal advice and meticulously guided myself and husband through every step of the spouse visa process. He helped us understand the errors of our first application, financial requirements, and other critical aspects of the application. Charles also advised on how to compile a compelling portfolio of evidence, from communication logs to photos and joint financial documents, proving the genuine and subsisting nature of their relationship. My husband has received his visa thanks to the dedication of Charles and his team at BWF Solicitors. Thank you for your expert legal advice. I highly recommend them. Nina says that. Uncle Ben, I think this gives you some excitement in your heart, doesn't it?
Yes, quickly it does. I mean, sometimes people don't understand why the immigration law is such a sensitive and emotive issue. Because families are dependent on it.
That's
and
right.
if one person succeeds, maybe potentially 2, 3, 4, 5, sometimes up to 10 people also succeed. And generations of people have opportunity to stay here lawfully.
That's
So if you do it right and you get it right and the client is satisfied, not only have you solved a problem for one person, but you've also opened opportunity for generations of children, possibly people who will be born here and they will go on to have children. And the other time I was telling someone that those of us who live here, when it comes to where you will be buried when you die, you need to consider, because you might think that it's just you, your wife, and your children. But by the time that you leave in another 50, 60, 100 years' time, you may have generations of Owusu,
that's right.
and they want to know where was my great-great-grandfather buried. So it's always important that when you're doing these things, you do it well. You use all the tools that you have at your disposal, and that include law, experience, and also sometimes guidance and precedence.
Yeah, I know people who have passed through your hands exhibit some of the qualities that Nina was talking about. Being meticulous, being very organized, striving for excellence, and the rest of it. It belabors the point, but I will ask, why do you insist on these?
Quick, that's my nature. I mean, I'll give you a typical example. Yesterday, I was looking for a file, I couldn't find it. I know I've given it to someone, because the only way you can teach people is not a theory, but it's theory and practice, which means that they have to apply their hands on the
That's
ground.
right. Yeah.
And I couldn't find it, but I knew I'd given it to someone. So, and after about another person goes, hey, I've got it, I've done it. Well, so I explained to her, and I said, now, this is me. When I set off from home, I know what I'm coming to do.
That's right.
But along the way, you then have things that you have to resolve. And if I don't resolve it, it then upsets my day. Not me, it upsets my day. The way that I have come to understand law is that the best arguments always win.
That's right.
So to get a best argument, you need to know what the argument is. Language. You need to have the language to deploy the argument. And the focus is always applying your mind to the situation. Do it over and over and over, and then you perfect it. Now, when you present, I'll give you another typical example.
Right.
There are people in the Home Office who refers cases to us. So when somebody goes there to sign or something happens and they can see that the person is struggling, they will say, go and call these people.
They'll help you.
And then they do. So, quite cool. And also, your work is not just for now.
Obviously.
It's for a long time. So 10 years, somebody may want to go for the file. If the grammar is poor, the sentence is wrong, the legal argument is poor or is wrong, then clearly you undermine your own credibility. But also, what have you learned? And that is why we apply ourselves consistently. And any person who's worked with me will see that it's non-stop. I know sometimes
it's a bit frustrating for me. Like that. Why is this man doing this, insisting on this and doing that?
Oh, the man is on the plane. He's in flight. And he's still working. And but that's my nature. And it's for me always acquisition of knowledge, information. And that's the only way that you can perfect yourself. And I believe that most people who work with me will all also have the same tenacity and ability.
Yeah. So if you want the best, go to the best. And I recommend highly BWF Solicitors. They're on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. If you go by public transport, you go the Victoria line and you exit at Seven Sisters, use exit number 2, go to the frontage of Anna House, climb up to the 4th floor. They're there Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call them on 0208 493 7340, 0208 493 7340. Or in emergency situations, call Uncle Ben on 077 127 61884, 077 127 61884. Again, before we go on to that, last week there's something interesting happened. I think it was on Sunday. We met on Saturday at the Ghana Property Expo and Lifestyle Show. Then Sunday, this gentleman came there. Oh, I came to look for Uncle Ben. I understand he was here yesterday, but today he didn't come. I said, yes, his SWAT was yesterday. He didn't come. Would you be able to give me his number? I said, yes, get your phone out. Then I called out the number. He looked at me as if something's gone wrong. I was like, why? Is anything wrong? But how come you have the number? Like, oh, no. I know this number of time. I've been dealing with the number for so long, so don't worry. So, yeah, you should have that number. There was this man that was speaking on radio in Ghana and said, this is my number. If you type it on your phone and it appears, then it means that you know me. Anyway, so I know Uncle Ben and I want you to know him as well. So keep that number on your phone, 077 127 61884. Now let's see what BWF Solicitors had to celebrate this week. One of our very own. You remember a few weeks back, we celebrated this wonderful lady when she completed training and qualified to the High Courts of, I think that's the right thing, to qualify to practice in the senior courts of England and Wales. Thank you. If you don't get it right, you're in trouble. And I think earlier on he was talking about the right language, the right terminology, so you get it. Now, Annie topped that one up with a very lovely milestone in her life, celebrating her birthday. Annie, listen, we have wished you and we still wish you fantastic time filled with joy. Your dedication and hard work are truly appreciated, and we're lucky to have you on the team. Here's to another and more years of success and happiness. Happy birthday to you, Annie. We offer a hat to you. Congratulations on your achievement and happy birthday as well. I know same time next year, I won't be sitting here alone. I'll be on the set with you and we'll be celebrating our birthday. Now, listen, the stable of BWF Solicitors has a lot of good quality. and you should come and see, feel, and experience the sharpness of thinking mind and what they do. Annie, you are part of that wonderful team. Congratulations, and we're proud of you. Happy birthday. Um, as I said, I'll bring you on. I've had a conversation with you, so you'll be sitting in my seat very soon when Uncle Ben allows me to go on retirement. Thank you very much. Then let's learn something as well. Let's see what nugget we had earlier in the week. We're talking about working time regulations of 1998. Now, holiday entitlement refers to the legal right of employees to take paid time off work for rest and recreation. In the UK, the Working Time Regulations 1998 govern holiday entitlement, setting the minimum standards for workers' paid leave. Under the regulations, most workers are entitled to 5 to 0.6 weeks paid holiday a year as a statutory minimum, which includes bank holidays unless contractually excluded. Part-time employees are entitled to a pro rata amount of holiday based on their working hours. Uncle Ben, let me ask, is it compulsory to go on leave?
Well, the case law, there's a Supreme Court case law, the case of Harper, where the person was not encouraged to take it. The employers are actually supposed to encourage the employees to take paid leave.
Paid leave, okay.
I think sometimes people say leave, but it's not a leave, it's a paid leave.
Okay.
Because it's not just going on holiday or taking time off. It's being paid.
It's being paid to take time off.
Because if you're taking time off, you're not being paid. Most people will not take time off. Then they're going to lose money.
Okay.
So the emphasis here is on the paid leave.
Okay.
And it's compulsory. It has to be taken. I know some people don't like to take holidays. Some of us hardly take holidays, but we do take rest time as well. But yes, you have to take time, else you will be burnt out. The business need means that you always have to negotiate your leave, and you negotiate that with your employer, because the nature of some of the businesses is that you need to plan very well, especially if the person is very sensitive to the work. Then you need to be sure that there's a proper and relevant cover in place for the person to take their paid leave. Yes.
Okay. So we're saying that you have to do that, and I think there's this saying that all work and no play make Jack a dull boy. But obviously, the reverse holds the same, that if you play all the time, you become a lazy person as well. But when you work so hard, you need to take time off. There's a reason why you start at 9 and probably finish at 5. There's a reason why there are bank holidays. There's a reason why certain festive periods are celebrated and taking off work. You need to rest and refocus so that you can be more productive as it is. Even with machines, sometimes we stop them for them to have a rest, and then we service them to function properly. So it is good that the regulations of 1998 are saying that you are entitled to that. But then there's one thing that says that part-time employees. Why is that differentiation?
So when somebody's working full-time, they're working full-time throughout the year. Bear in mind that your annual entitlement is calculated over a year.
Okay.
So in the year, you're entitled to 50.6. Now, when you calculate that's 39 days, the maximum you can take is 28 days. That is including statutory public holidays. Right. So although it says 5.6, it is there to help you calculate. Right. So when somebody's working part-time, their holiday will be based on 39 days because it will be multiplied by 5.6.
Okay.
The part-time people cannot take 28 days because they're working part of the week and not all. Okay. And your holiday pay is based on your weekly pay. Okay. You may be working monthly, but it's based on your weekly pay. Okay. And therefore, if you're working 2 days or 3 days, it is the amount of money that you're making, your gross income, that will be used to calculate your holiday. And so when we say maybe 15 days or 15.6 days or 15.8, it is not just the day off, it's the money that has been paid. So if it's a week, 15.8 will be about 2 weeks plus a day and a half. That is what the number of days say. So you prorata it. When we say prorata, the number of days times the number of the number of days of the week times the
and then the
annual
hours and the
entitlement,
amount you pay.
and then that's but also there are people who have irregular work, zero contract, and people who are called now and then work for agency. They are all entitled to paid time off. And there's a new law that is coming the 1st of April this year. And that law also regularizes those people who have irregular work. So, for example, somebody may be called to come and work today, and they will not be called for a month. And then they will be called again to come and work for a week, and then they will not be called for 2 months. Those are irregular patterns of work. All of them are entitled to paid time off.
My next question probably may put you on the spot because you're an employer. If somebody has taken paid leave and there is some requirement at work that the person came back to do and called out of leave to come into work, in that case, is it within the law to pay for that time, or the person can take the time back?
Well, for example, if somebody goes on holiday and they've taken 2 weeks holiday, and then on the 10th day you call them in, and they voluntarily, they don't have to come. They don't have to come.
Yeah.
They voluntarily decide to come. They still got 4 days. So they didn't take the 4 days. They only took 10 days.
Okay.
And the day that they're working, of course, you're paying them the normal rate. But when they take the 4 days, you still have to pay them.
Okay.
So they don't lose out. And just sometimes I always say that employers and employees always, if you have a good relationship, people will be willing to sometimes, even if they want to take 10 days, they might say, okay, because of this and that, I want to take 7 days, and I will take the 3 days later. One of my employees wanted to take time off next week. And I said, no, this is one of our busiest times, so wait and take it in January. And she agreed. So some of these things you just have to negotiate.
Oh, okay. All right. Well, that's what it is. I knew that question would come, obviously, so I had to ask about it. So, yes, remember, you would have to take your leave because you're entitled to it. And employers are obligated to pay you whilst you're on leave because they need you to rest. Now, watch this. I'll be asking you a question about that. So, later on in the show, I'll be doing that. But now let me just welcome people who have joined us on the line. And what we do here is to ask you to announce yourself, and then again, also keep your comments going through the comment section, either on Facebook or YouTube, where we are live. We're live on Facebook and YouTube at BWF Solicitor and at BWTV. I know definitely. Am I calling Tilly? Yes, Tilly is here and calling Penelope Pinzo. Abina Wa Asantua Papebi is here. Asafu Ajari, you're watching with us. Thank you very much. Ata Damua, you here. We also have Margaret Edu Mensa calling you to come in here. Abdul Wahab Osman, thank you. Obapa Gifty, thank you very much. Derek Smith, you are online with us. Gideon Ajay Binding, thank you, Gideon. Kapoke Akufu, Lolanda Apieje Frimpong is also watching. Asamoah Bodi, Malu, Kofi Akubia, Benjamin Markwe, Charles Emery, Dibane Du Das. You're also watching with us. Thank you very much, my brother. Samuel Opukudonko is here. Matthias Frimpong, Grobert, Ni Ama, Nana Krios, Constance Adema, Nana Bafo Jew, Asante Richard, and a host of others. So when you come in here, please announce your presence. Keep your comments in the comment section below. If you have a question to give to Uncle Ben, you can text it to us on 07399208468, or you can call us when the lines are active, 0208-493-7345. That's the serial number, and or you can also leave comments and questions in the comment section down below. We're live on the Community and the Law, brought to you by BWF Solicitors. Let's say thank you to them and come back to go into our main discussion.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. We so privileged to have the senior partner of BWF Solicitors as a resource person and guest this afternoon. And we're going to look at skilled workers and visa applications for child dependent. We're going to specifically look at how to avoid the trap of sole responsibility. That conundrum, sole responsibility. Today we'll have a look at it again, have it defined, then link that to the skilled worker route applications that we make, and what it is that the problem is when it comes to making an application to bring your children to come and join you when you have migrated to the UK as a skilled worker. Uncle Ben, this sole responsibility thing, why is it so big an issue?
Well, Kweku, first of all, it's an issue because if you don't meet that in the eyes of the caseworker, it means your child will live in a different country from where you are.
Mm-hmm.
And most people who come here, they come here because they know that they can bring their dependents, including their children.
Mm.
So if for any reason they prefer to come here before they bring their children, even if they've been here for a few months, the caseworkers sometimes are fair, but most times, in my assessment, that's my personal opinion, are unfair to them. And the unfairness stems from the fact that the law allows them to do an inference and do their own objective assessment based on the evidence. But we know that it is objective in quotes, but eventually is
Quite
their
subjective.
worldview that they use to determine whether the child has to join the parent. The rules have changed, and the rules have now been merged. All children application have now been merged together under appendix child, and the reference is appendix CHI. And as part of the processes, there are two main eligibility requirements: the relationship and also the status of the person who's here. The reference here of the status is those people who are here as skilled workers.
Okay.
And they are the people who this affect most, because if somebody is here on a 2.5 years or indefinitely and they want to bring their child and the child is refused, they will go to court. But for a skilled worker, because they don't have a right of appeal, the decision will go for an administrative review.
Okay.
And administrative review, there are three main problems that I have identified. The first one is a delay. So as we speak, there's a delay of about 12 months. So,
and if that is picked up, then if the person is also in a 2-year or 3-year contract,
yeah,
the period is almost up.
that's right. The second one is it goes to the Home Office. So they cause a problem. You're asking them to rectify the problem. And then the final thing is that you're not allowed to bring any extra information or evidence to challenge the decision. You're only challenging the decision because it made an error, either administrative error or a legal error.
Mm.
The problem with that is if the foundation on which the application was made is not solid, then really all you're doing is just wasting time. And I've told people that for us, once this is a live issue, you need to work from backwards to front. You don't work from front to backwards. First of all, and I'm talking to the mothers especially, if you're here and you want to bring your child, if only one parent is here, then the issue of sole responsibility will come in. And usually this will be fathers, but most often than not is mothers. So they travel here. They're no longer in a relationship with the child's father. The child's father lives either in Ghana or Togo or Armenia or America. The Home Office doesn't care. All they care about is that you are the only one here, and the child is coming to join you, and he's not coming with the other parent. And therefore, if the other parent is still alive, then there will be sole responsibility. The sole responsibility is to show that you have control and direction.
Okay.
So I always go like this.
Like you're handling the steering wheel?
Yeah. And then this.
Looking forward,
because
focusing.
that is what you have to show in the child's life. So you have control and then direction.
Okay.
Well, how do you show control and how do you show direction? So that's why I said you go back and you start from the back to the front. And this is something that I've thought of. In fact, there's things that I'm going to introduce, which is new, which we don't even use. We're now going to use from today.
Okay.
And I'm trying to create something novel so that we also want to catch the Home Office and also punch back. So everything I'm saying now is something that I've thought about. Maybe even the lawyers in my office may not be aware that we're now going to do this, and I'm giving it to you free of charge.
Right.
So
that's the essence of this program and the advantage we have. So sit back, get alert, and let's go into the strategy. What is it, Uncle?
Okay, so back. When I say back, I want you to go as far back as when you created that beautiful human being called your child. It may be that you created them 14 years ago. It may be 10 years ago. You are the mother or you are the father. Remember that day that you gave birth to the child, the joy that you had.
Obviously,
that is called bonding. Everything that you did from there, if it was negative, the child will not have survived for 14 years or 10 years. So you exhibited love. You exhibited direction. You exhibited control.
That's right.
You took charge of the child. You took them. You bathed them. You fed them. You gave them breast milk. Start preparing a diary as part of the application. And you can get some of the information from the weighing book, from the health book, and
what they call the red book here in the UK.
Here is red book. If you're here, you don't have a problem. There's no sole responsibility. So this is from Ghana, or wherever you're coming from. Create a picture in your mind. It might be that you didn't document this, but you know when your child was 6 months old, you know the milestones you met, you know the things you did, you know when your child started crawling, the things you did, you know when your child started kindergarten, you know when your child started nursery 1, you know when your child went to primary school. All things you did, remember you did something. You took the child to hospital. Which hospital did you take the child to? Put it in the story. You took the child to a childminder. Who was a childminder? Put it in the story. You know what you're doing.
Yeah.
At that age, the child has no say in their life. They cannot fend for themselves.
Obviously.
So everything you're doing is control and direction. The law wants you to show that Although physically you're not present with the child, you still exercise control and direction. So I've told you, you found primary school for the child, maybe they're going to secondary school, you found secondary school. Write a story. I've said this before last week, but I'm firming it up now and I'm putting it into context. Once you've done the story, if you've got photographs, if you've got written documents, maybe the teacher wrote something to you or the doctor wrote something to you that thank you very much. We've done this test. This is what has happened. Your name is there. You were part of the process. Maybe the medical notes will also help. You've created a diary. You've created a story. You've written a professionally written statement, and you've incorporated all pieces of information from the age of 0 to now. All the things you did to the day you left. Now, before you left, something important took place. You handed your child's care and control
to another person.
Who is this person? If the person is a relative of the father, if you are the mother, and if you are the father of the mother, then there's a problem. Because the guidance note says that where the child is being cared for by the absent parent's relative, then showing so responsibility can be a problem. So again, I'm giving you warning there.
That's
you
right.
know what to do. But there's something that I will also add for all of us to show some care. Now, when you come here and you're physically here, there are things, you've taken a decision there. So document that. But when you're here, there are things that you still do.
Obviously.
The
Because
child-
you're in control. So
Yes.
decisions will not be taken without your consent and approval.
Absolutely. So, but how did you take the decisions? You spoke to someone. Who is this person? This person may be your mother, your father, your sister, your brother, your relative, or your friend. How did you take the decision? It will usually be a phone call. Show that you call this person regularly. Maybe you speak to the child because the child has got a phone, so you can call them. Even if the child is in boarding school, at the time they are away, you can still call the house teacher or the housemaster, the headmaster. You can ask about the child, how they're doing. Please, not all of us can read and write.
Obviously. Yeah.
But we can do voice recording. So these days when I'm busy and my thumb hurts from the so many questions that I've answered,
you just do your voice notes.
I do my voice notes and send. Voice note, you can do the voice note. If it's in Twi, it's perfect. If it's English, it's even better. If it's Twi, we will transcribe it and add it to the evidence. That these are the communication and the evidence of you showing, taking control and giving directions. You have to add it. But there's something that everybody does. And technical team, if we can put our guidance notes there. There is a case law which says that Home Office guidance note. So as you can see, it's called guidance. And usually it's called guidance for Home Office caseworkers. This is not me, I didn't write it. So we want to use their own facilities and law to fight back. Now, what does it say? Say appendix children. It was last updated on the 11th of October. That is the latest one.
It's about a month or so ago.
That's correct. So everything there is new. Now, when we scroll down, let's scroll down and see. Hold on. This guidance is for decision makers who are deciding applications for children. So when you make the application for your child, you didn't make the application.
You made it on behalf
of your child. So you can see there. Yes, including those applying as dependent children, where appendix children applies. Did I say something earlier today? I said they've amended all the children's law and put them into one, and it's called appendix children. For the purpose of this guidance, a child means person aged under 18, unless applying as a dependent where the applicant was aged under 18 and now is over 18. Let's go down. You see what it covers? It covers almost every conceivable immigration route in the UK. Pause there. Pause. Kweku, this is where we said that when you're doing your application or you're making your application, The caseworker is supposed to be objective,
Mm-hmm.
but they are not objective. And I'm happy to say they are not objective. Look at what it says here. The burden and the standard and burden of proof. The burden of proof is on the applicant, so it's on the child. Okay?
Mm-hmm.
So your child has to prove all this.
Okay.
To show they meet the requirements in appendix children. The standard of proof is a balance of probability. So in law, where they say it's a balance of probability, it is the part of the evidence which has more weight than the other. Sometimes something may appear true, but somebody might say, I believe this more than this. So when you balance all the probabilities, probability means it can be A or it can be B. So where they say this is mandatory, you should have done this. Oh, I believe that you got this report because you want your child to come. Oh, I believe that you didn't do this. I believe that the child's father is in Ghana. I believe that the child's father is involved in the child's life. Why does it say that they can say that here? They cannot say that. So you have to quote this to them. At the beginning of your application, you say, I make this application on behalf, and this is what your lawyer will do, on behalf of my child. And as you may no doubt be aware, the test in this case is on the balance of probability. So it doesn't mean that everything has to be 100%. It's on the balance of probability.
You have to make an argument that will weigh in your favor.
That's correct. So let's go down. And this is where I want people to start reading. And if they don't read, they should use lawyers. Pause there. You cannot make a child's application without quoting this. There's a duty by the Home Office towards children. So Section 55 of the Borders, Citizenship and Immigration Act requires, because we didn't say on the balance of probability.
But this is,
it's a duty
to do that, yes.
Requires the Home Office to ensure that immigration and nationality functions are discharged having regard to the need to safeguard and promote the welfare of children in the UK. It says in the UK. But in the other round, when you read further, it says, although the child may not be in UK, any decision we take about children, whether they are in UK or not, we need to exercise this duty of care. Yes? It says that. Let's go down. Adai, let's go. Pause. Go up slightly. You must carefully consider all the information and evidence. Kweku, what did he say? He said you must
carefully consider.
So when you send evidence to support your child's application and they don't consider it carefully, they breach their own laws. And this has the effect of law. If it's in your favor, if it's against you and it's against the law, then the case of Adiola doesn't allow this to be part of the law if it's against you or against the immigration rule. But look at it. You must carefully assess the quality of any evidence provided. Original documentary evidence from official or independent source must be given more weight. More. What did it say again? I want you to read that for me.
It says you must carefully consider all the information and evidence provided to ascertain how the child will be affected by this issue. You must carefully assess the quality of any evidence provided. Original documentary evidence from official or independent sources must be given more weight in the decision-making process than unsubstantiated statements about the child's best interest.
Okay.
So if I have an official document
from the child's school,
from the child's school,
from the GP,
from the yes,
from the scouts,
that's right,
from the football club,
that's
from
right,
the gymnastics club, from the piano lesson club, all these are independent official sources of documents. At least 3 of them: school, church, hospital. And I also sometimes add the pharmacy or the chemist.
Okay.
These are not your family members. So, parent, if you're listening to me and your child has been refused and you provided this document, please, if you don't mind, go back to the decision and take a screenshot of what is said about the documents from those people. They will tell you that, oh, this evidence is self-serving. It is because you want your child to join you. That is why you've asked the school, the hospital.
But it's an official document.
Absolutely. So they, in effect, are going against their own instructions.
Yes.
And that is why I have carefully taken my time to look at this. For all refusals, the decision notice must demonstrate that the relevant information and evidence provided about the best interest of the child in the UK have been considered. You send evidence to them, they don't look at it. They said, oh, you didn't bring it, but meanwhile you sent it. Once you notice that they haven't looked at that evidence, refer them to this section of the guidance note and says that this is a duty you have. Because you haven't considered my evidence, you have breached this duty. And therefore, the administrative review, and that you say that your decision is wrong. Let's go. Let's go. Let's go. Okay. Now, when you're bringing a child, these are things that people don't say. You must make sure that there will be someone here to look after the child. And if you are here, you are the person who is well placed to look after the child. Yeah. So all arrangements for children's care and accommodation in UK must comply with the relevant UK legislation and regulation. You must be satisfied the applicant will be living with their parent or their parent's partner who has permission on the route under which the applicant is applying, right? In most cases, let's go slightly, where the child will be living with a parent or at school or college or university, there is no need to undertake further checks on the suitability of the care arrangement. I've seen cases where they refuse them because you haven't put in place an appropriate care facility for the child. What does it say? They're coming to school or they're coming to the
parent, college, university.
And what does it say?
Those are formalized arrangements.
Absolutely. But then it says, in most cases, where the child will be living with a parent or school or college, there's no need to undertake further checks. So why are you asking questions about that there are no appropriate facilities for the care of the child? And that's why I keep saying that we need to look at this very carefully. But there's something that is going to blow people's mind. And I think it's the next one. Let's go. Okay. We're going to the consent, Adai. Yeah. Okay. Now, Kweku, please, I want you to read this because I want us to go through this carefully.
Okay. Now, parental consent requirement. This section tells you about the parental consent requirement for applicants who are aged under 18. To meet the parental consent requirement, the applicant must have written consent from either both of their parents.
Pause there. Please, what word did you use?
Either.
Either means what?
One or the other.
So did he say both?
No.
Did he say the parent in Ghana?
No.
Did he say the parent in the UK?
He never mentioned
So mother and father. Why do you say my lawyer told me to ask the father who's in Ghana to give consent?
Because you who's making the application on behalf of the child.
Absolutely.
Is one parent.
Yes.
And you can write a consent letter to back up the child's application.
Because when we say control and direction, care, control and direction, it includes taking decisions on behalf of the child. You are saying, dear, who's the minister, Secretary of State for Home Department? Oh, I've forgotten what her name is. Dear Madam Secretary of State for the Home Department, I am bringing my child. The father is not in the child's life. That's what you're saying. The father is not in the child's life. Then the case worker says that we need consent from the other parent.
Why?
And then you say, your lawyer says, oh, go and bring consent from the other parent. But you're saying that, dear madam, the other father is not in the child's life. The law here says that it can be from you or from some. In fact, it can even be from the guardian. It doesn't have to be. So let's read. I could read that paragraph again.
To meet the parental consent requirement, the applicant must have written consent from either both of their parents, one parent if that parent has sole responsibility for the applicant, their legal guardian or guardians.
Yes. So where you have sole responsibility, it must be from you. Yes. Now you're dealing with the issue of sole responsibility. And then you go and collect consent from the parent
who's not in the life.
You claim
that
he's not in the life of the child. Meanwhile, a lawyer has told you, the man is not only written, dear sir, I'm the father of this man, I'm not in his life, I don't really care about him, whatever he does with you. But he said, dear sir, I'm the father of 𝗖𝗢𝗠𝗠𝗨𝗡𝗜𝗧𝗬. I give consent for my child to go and join his mom.
But you are not in the child's life, so that responsibility, who give that to you?
And it doesn't end there. They go to a lawyer in Ghana and he types an affidavit. I am a manager of this. I have money. I live in my own house and this and I want my child to go because his life in UK is better than the life in Ghana. Ebe. How did we get this so wrong? And I want you to stay there. If you can highlight it in yellow for people to take screenshots of this, and if somebody tells them that no, their consent is from the other parent, they should just show this to them. I don't know whether you can highlight that. If you can, please do. Kweku, this is what is killing the mothers and the fathers from bringing their children. And for some reason,
highlight from the heading, parental consent requirement up to legal guidance, and I think that's what people would have to take note. Thank you.
And this clearly means that most of you, and I mean a lot of them, have been doing it in the wrong way. They have been defeating the very purpose for which they are fighting for. And in fact, they're giving an arrow to the bow of the caseworker to shoot at them. And unfortunately, this is what we must stop. But above all, it doesn't end there. Ada, you could take it off. Once you've made all these claims that I'm the mother, I've done this, I breastfed him, I took him to nursery, kindergarten, this is a letter from the kindergarten, I took him to primary school, I took him to secondary school. These are all the evidence, and I haven't stopped. When I was leaving, this is what I did. I handed my child to my mom. Look, I speak to my mom regularly. These are the call logs, the text messages, the voice text that you've sent. They are all there. You don't stop there. You then add, in addition, I have family life with my child. And if you exclude my child from coming to the UK, you have breached his family life and therefore his human rights. The reason why I'm bringing this is that in law, when we say a human rights claim under Section 113 of the Nationality and Immigration Act of 2002, it includes life that you have with your child who is under 18. And if you claim a human rights aspect of the law and it's refused, it gives you a right of appeal, or at least in principle, it should give a right of appeal. Just remember that for administrative review, for skilled worker route, when you refuse, you don't have a right of appeal. You have a right to administrative review, which is a poor man's right of appeal. What it means is that the Home Office are going to bully you again. They're going to delay it for 1 year. They will come back and say, oh, we are sorry, we made a mistake. We didn't look at this document. We looked at it again, but we still refused you. And then you have to go for judicial review. But I'm saying that put this in, refer to Section 6 of the Human Rights Act of 1998, refer to Section 113 of NIA, and then refer to Section 55 of the 2009 Borders Act, and then explain why this is a human rights claim. Just say that your child has been dependent on you all his life, he's still a child. Most of the things that he does, it is through your direction and control. Yes, sending money is good, but it's only one aspect of what we're talking about. And the final thing I want you to do, your conclusion is that, therefore, this is a human rights claim. And you have to explain why it's a human rights claim. You cannot just say this is a human rights claim. Therefore, this is a human rights claim. And as you may no doubt be aware, human rights claim under Section 113 of the law that I referred to and the 1998 Act, Section 6, if an application is a human rights claim and is refused, under Section 82 of NIAA NIA 2002, it gives rise to an appeal. We will argue about this. There's a case law that I will bring, but not now. For you, it's not important. All I want you to do is write like a lawyer and behave like a lawyer. Please, and I must say this again, don't go and take consent from the other parent you claim is
They are
not in
not
the
in the
child's
life of
life.
the child.
If
Yeah.
you do that, you would have undermined the child's application. And remember that custody order from the court is not the same as sole responsibility. You may have a custody order and still not have sole responsibility. So when a lawyer says to you, go and apply for custody order in Ghana and spend so much money on it, and then they go and add a statutory declaration for the absent father to say that he gives
that
you,
spoils the whole thing.
you've spoiled the whole thing.
Well, if you just joined us or if you have been with us, we've been looking at the issue of sole responsibility, and we're using the Home Office own guidelines to case workers to point out that we are taking those sole responsibility decisions in the life of the children. Remember, if you're making an application for a child to join you, you are doing that on behalf of the child. So you are one of the parents that has a right to be writing a letter of consent for the application to go through. I know you would be having a lot of questions. You will be having a lot of concerns here. Keep your questions coming through 07399 208 that for text messages and WhatsApp, or you can keep them in the comment section below. We're not done with the discussion. We're taking just a quick break, and when we come back, we'll be looking at, Uncle Ben mentioned that he was going to refer to a case and also to look at some of the trends that are happening and some of the responses that we've been receiving. And when it is that you see those, what signals do they bring out and how you surmount all those things? It's a community in the law and is brought to you by BWF Solicitors.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you very much for sticking around. And we're live on the program, The Community in the Law, brought to you by BWF Solicitors. We're having a wonderful chat and discussion with Mr. Bernard Owusu, senior partner of BWF Solicitors. Uncle Ben will call him. And he's taking us through skilled workers and visa applications for children dependent. And he's telling us how to avoid the trap of sole responsibility. We have this part of the discussion, and I believe that we can put it back on. I just want to read that last bit that we asked people to take note of and we highlight. Parental consent requirement. Now, of the guidance, that it tells us that the parental consent requirement for applicants who are aged under 18. To meet the parental consent requirement, the applicant must have written consent from either both of their parents, one parent if the parent has sole responsibility for the applicant, and then their legal guardian or guidance. Let's go to the very top. Is from the Home Office own guidance, the very, very, very top. I just want to have that. Yes, it's from Appendix Children Accessible, updated the 11th of October 2024. Uncle Ben, this tells me that Home Office keeps reviewing their guidance. They keep giving you directions here and there. Skilled worker route has become highlighted in recent times. Have they changed several other things that really come from the Home Office responses? Some of the things that really would go in our favor. Has anything changed?
Well, what we've recently found out that some of the decisions are taken by AI, artificial intelligence, and today my Ashanti has come, so I'm not going to pronounce that word. There's a word that you have to pronounce. I don't know what is it. Is it
algorithm?
Algorithm. So the Home Office is now using, if we can go on the internet, the Home Office using algorithm to make decisions.
They're using AI. Okay.
AI. So they're using
artificial intelligence to make decisions.
And artificial intelligence, although it is artificial, but it's not intelligent.
No.
Because intelligence includes emotional intelligence. And the artificial intelligence, which is a machine, does not have emotional intelligence. And that's it. It's in the Guardian newspaper. So I'm not lying. And they've admitted AI tool could influence Home Office immigration. Critics say a Home Office artificial intelligence tool, which processes enforcement action against adult and children migrants, could make it too easy for officials to rubber stamp automatic life-changing decisions. So this is what is happening. And the sad thing is that these are life-changing decisions, and the life-changing decisions is about a mother who wants, or a father who wants to be reunited with their child. And most often than not, the only reason why they came here is they knew that they could bring their dependents with them. And if this artificial barrier is put in place to prevent them from bringing their children, then really the goalposts has changed. But I tell everyone that it's a fight. I know in the long run we will win. There are so many things that we're doing, including what I've just done today. And I'm sure those people who are watching, if they are helping people to make the applications, will also incorporate it. The reason why I brought this part in is that in law, if the Home Office serves you a decision, and it's a human right decision under Section 113 of the Nationality, Immigration and Asylum Act 2002, if it's a human rights application, and the human rights application is defined there as any decision that involves the Human Rights Act, which may lead to your removal or prevention of coming to the UK. That is a human rights decision. If a parent is bringing their child, it involves family life. When you look at Appendix CHI, Appendix SW, I think it's XW32, which is a skilled worker route for dependents. When you compare the two and you merge them, apart from Section 55, which talks about the welfare interests of the child, there's nothing in there which takes into consideration the child's human rights. So that's why I'm encouraging everyone, when you make children's application under sole responsibility, you also need to add an Article 8 aspect. When you're filling the forms, they ask you, is there any reason why your child cannot go back to Ghana if you're here? Or is there any reason why, or do you want to add anything to this application? Say that I am making a human rights application on behalf of my child. And if you're a lawyer, you should put it there and put in your cover letter. I'm aware that under Section 113 of NIAA of 2002, a human rights claim is similar to what I'm doing. I'm aware that when this is refused, and if you refuse it, I must warn you that I will be taking the case to the first year tribunal under Section 82 of the same Act, because I am also adding that by the refusal of this, you see the cover letter said from the back to the front, all the life story that you've had with your child, the fact that you've looked after the child, you've cared for the child, you've had a bond, the child is under 18, the presumption is that the child has human rights or family life with you. And if that family life is going to be severed permanently, because that's what they're doing, they want to sever it permanently by not allowing the child to come, then it's against Section 6 of the Human Rights Act, because it's against Article 8 of the European Convention on Human Rights. Put it in there and send it. When they refuse a decision, let them know that a decision of this nature, although there's a statutory administrative review, you're saying because you made a human rights claim, they should have dealt with the human rights claim and informed you that you have a right of appeal in addition to the administrative review. It's up to you to choose. Because when you look at the Immigration Notices Act 2003, Section 5.3 or Regulation 5.3, there's a new case that has just been decided. It's a case of Chowdhury versus the first year tribunal. And the courts have said, and we've always known this, the courts have said that if the Home Office doesn't serve you with a right of appeal, then the decision they've made, they haven't finished. The decision is still outstanding. But they need to comply with the Immigration Notices Regulation 2003, specifically Regulation 5.3. And that's why I want you to note the following things. 1, document all your child's life with you. 2, make sure that you collect, what did we say, official independent sources of information and evidence.
So letters from school, hospital or doctor, church.
Yes.
The play groups and other bits that they enjoy.
That's correct.
It could be from the chief of the village.
Yes, if he's aware of your situation. Yes, if somebody who knows you and the child have had a life, continue to have a life, they can write, and we've read a guidance. It says that it should be given what?
It be giving.
It should be given more weight. It says giving more weight than merely saying it. So if you say, my child, I found a child at school, they will give you weight. But that weight, if it's 100%, it will get 20.
But if you add an official correspondence from there, then it should add another 80 to it to make it 100%.
And that is why when the Home Office then ignore those letters, you have to refer them back. When you're doing an administrative review, you have to refer them back to their own guidance to say that you have not complied with this, which is an order to them. That when you're looking at children, if there's official and independent source of evidence, and even a letter or a report from an independent social worker, it's independent and it's official. They should have looked at it. They should have given it more weight, and they haven't given it more weight. And therefore, that in addition to the human rights claim, which they haven't looked at, they haven't applied Section 55 properly, you can then take the case to court.
Now, I think then the advice obviously would be, Ahmed, that you preempt some of these things by referring to Section 55, quoting the relevant parts to support your thing. Then, as that segment says, that official correspondence should be given more weight. You would have to get them to add to your application. Then in your extra notes or cover letter, you state that you're making a human rights application and that all these things come into play and that they should look at those things, give it the weight it demands, and make a decision in your favor.
Absolutely. And I'm happy that you have summarized all the big English that we've used here today. And I'm hopeful that those who are looking at it, because a number of cases that come to us after the parents have gone to provide the consent from the other parent, we always try to rectify it.
That's right.
But it's always the case that, now you've got a lawyer, you see you haven't added this one. But the first time you brought it and we refused you, you've gone to instruct a lawyer, and now you haven't added this. So we're going to refuse you because we are looking at the first one. The man is still in the child's life because we have told you that when you claim that you have sole responsibility, the consent should be from you and not the other parent. And the consent can even be from your mother in Ghana to say that, this is my grandchild, I'm the guardian, I'm happy for the child to go. But I'm saying don't do that. You write a letter, I'm the parent, I so and so, I'm in the UK, I give consent for my child to come and join me. Absolutely. Don't go and be deceived. I've seen cases where it's been done by lawyers and they've made the same mistake. Because, but they said it's compulsory. Who says it's compulsory? In the children, appendix children, it's not even there.
It's not even there.
No.
It never said it was compulsory.
No.
It said letter from either.
Absolutely. It says either. And the word there is either. I know that sometimes we don't like reading. And when we see...
But I mean, the little tricks. Somebody said when a lawyer says is, it doesn't mean the is that we know. It could be something else. So in law, when it says either or, then it means that there is a caveat there that you have to pay particular attention.
It means you've been given options.
Options, right.
Alternatives.
That's
so you
right.
can choose one of the options. And if you go and choose a bad option, it's a bad decision. It will follow you for the rest of your life. And I hope you don't choose bad options.
Anyway, I think your best option, obviously, is to rely on legal advice and expertise from BWF solicitors. They're located on the 4th floor of the House, 214-218 Tottenham High Road, Seven Sisters, North London, London N15 4NP. Now, call them, speak to them. They work from Monday to Friday between 9:30 and 6 p.m. 0208 493 740. They have an office in Ghana as well. So those of you in Ghana, you can call 055 589 5959 055 589 5959. Or the emergency number is a UK number +44 77 127 61 884. BWF solicitors are trusted partners when it comes to the law. Now, do you remember this? I talked about the paid leave. I was hesitant because Ankuben corrected me that it's paid leave, not just leave. UK holiday entitlement refers to the legal right of employees to take paid time off work for rest and recreation. Now, here in the UK, the Working Time Regulations 1998 govern holiday entitlement, setting the minimum standards for workers' paid leave. Under the regulations, most workers are entitled to 5.6 weeks paid holiday a year as a statutory minimum, which includes bank holidays unless contractually excluded. Part-time employees are entitled to a pro rata amount of holiday based on their working hours. Now, I'm going to allow you, if you would want to call us on the phone, the number is 0208 493 7345, or you can put your comments in the comment section below, ask your questions. We're going to take those questions. So we'll take just a snap break. But before I go on that break, look at the scenario and see if you will be able to help me give an answer. Can we take this one off? Okay. Nana Kwadjufo works 3 days a week, equivalent to 24 hours in a week. Applying the working time regulations, how many days of paid holidays is Nana entitled to in a year? Now, this one, I know you have to crack your brains a little, and I'm compelled one way or the other to give a prize to whoever will crack it very well. Nana Kwadjufo works 3 days a week, equivalent to 24 hours in a week. Are you thinking around it? 3 days a week, equivalent to 24 hours in a week. Okay, I will say, applying the working time regulations, how many days of paid holidays is Nana entitled to in a year? Now go back to the nugget, and it tells you you have what, 5.6 weeks paid holiday in a year as a statutory minimum, which includes bank holidays unless contractually excluded. Part-time employees are entitled to a pro rata amount of holiday based on their working hours. Uncle Ben mentioned something here when we were explaining earlier on that it is calculated according to the number of hours you work and the amount you are paid. Okay, we'll come back to that. So that quick break, then we'll come to your questions because I know people have put comments and questions in the comment section below, and the text messages and the lines are also available for you to call in. It's still the community and the law, brought to you by BWF Solicitors. Okay, so the lines are active 0208-493-7345, or you can send a text to WhatsApp and text number 07399208468. And we have some comments in the comment section below on the platform. Let's go to Francisca's Bet. Good evening, Uncle and Brakweku. So, what is the do's and don'ts of naturalization applications? I mean, to qualify and disqualify me from getting my naturalization. That's Francisca's question now.
Well, I mean, there are several requirements. The most important is suitability and conduct. So that can disqualify you.
Okay.
And then also residence. So if you're supposed to do a 6-1, a 6-1 is 5 years, a 6-2 is 3 years. And a 6-1, you're supposed to be here for 5 years lawfully. And that you have been here for 12 more months after you got your indefinite. For a 6-2, you're supposed to be here lawfully for 3 years. And at the date of application, you have no time limit or indefinite leave to remain. Then the other thing that you shouldn't have been away for more than 90 days in a year. And then in the last year, you shouldn't have been away for more than 90 days. Now that can rise up to 970 days. Please. I'm not saying you, Uncle Ben said you can be away for now. No, please, I didn't say that. What I'm saying is that there are exceptions. And the exceptions comes with certain requirements. So you need to meet that. So residential requirement, the lawful residence, it's a requirement. Your suitability is a requirement. And finally, you need to do your English and life in UK. Unless you are above 65 or below 18, or you have a medical, psychological, psychiatry, or physical condition that prevents you from learning, preparing, and writing the exams.
With this at the background, I want you to help us clarify. People say that when you have lived on a route for, say, 5 years and qualify for indefinite leave to remain, when you have had a successful indefinite leave to remain application, you have to live on that for a year before you can apply for naturalization. Is this a blanket rule for everybody?
That's why I refer to Section 6.1. So the Section 6.1 of the Nationality Act of 1981 is those people who are doing application in their own right. So they are not married to a British citizen. They may be married, but they're not married to a British citizen. So the application or the qualification, the route is a 6.1, and that's 5 years. So 5 years. And then the 6.2 are for those whose spouses, and I mean married spouses, are British nationals. And then it's a 3 and 0. So 3 and 0. The other one, which I said 5 and 1. 5 and 1. So the 5 means you should have lived here lawfully for 5 years. And that you've lived here for 1 year after you got your indefinite leave to remain. A 6.2 is 3 0. You should have lived here lawfully for 3 years, and at the date of application, you've got indefinite leave. It didn't say wait 12 months after the indefinite.
Oh, okay. All right. Well, let's keep the comments and questions coming through. Uncle Ben is here. My employer doesn't pay anything when staff go on annual leave or sick leave. Can something be done?
Absolutely. That is again um, working time regulation. 1998 is unlawful. Sick leave is a statutory requirement, and your employer may be in breach of the law.
Okay. So, yeah, don't take that line down. Challenge it. Your HR section should be contacted, or probably go to your union. They will fight your cause for you. If a skilled worker brings her child to UK using social responsibility, and in a month or 2 or 3, the father who had no contact with the child or for all the years suddenly gets contact and play active role, can he regularize his stay based on the child's immigration status if the father is undocumented?
Once the word undocumented is, it means that the person is in the UK. And if the person is in the UK and the child was in Ghana, of course, the father would not have had anything to do with the child. So this is not a scenario that we're referring to. If the child is here and he's got some residence and he's got family life with the father may want to just be mindful. There are two main routes for parents to go through. There is the usual parents route, family life of a parent, and then there's the EX1 route. All require the child to be here for at least 7 years, or have indefinite leave, or has EU pre-settled status, or has an asylum status. Now, a child who is here as a skilled worker dependent doesn't have all of those. So your application is purely a human rights application, an Article 8 application, and you cannot miss. Or if you miss, you're going back. So you need to get a lawyer to do the application for you.
Well, that's solid advice and the best, of course. It's always the best for a layman to give his work for an artisan to do for him or him. Let's speak about the questions. This is from Nanechi Ahine. If a woman who is married to a British citizen on 5-year partner rules bring a child from his previous relationship, and in about a month, I think it's about the same question. Similarly, okay, let's go through it and might be a bit more. Um, about a month or 2, the child's father, who has never had contact with the child for years, suddenly has contact and play active role. Can the father regularize his stay if he's undocumented using the child on the 2.5 year by direct access? The child lives with the stepfather, biological mother, but biological father lives elsewhere. Similarly, if the child came with indefinite while the mother had divorced her British partner, but she is British herself. Can the father regularize his stay based on the child? I think that's a bit more.
The easiest of the route is the second part, which is a child is got indefinitely. We know that one of the grounds to become a qualified child is if the child has indefinite leave to remain, has lived here 7 years, or the child has limited leave to remain, or what we call it pre-settled status. That is the easiest one. The next one you mentioned is a 2.5 year. That means that you're making an application purely under human rights.
Okay. Well, the lines are active 0208-493-7345. You can also text to 07399208468. And then again, you can leave your comments in the comment section below, both on Facebook and YouTube. Can I travel here? I have only 1 month visa in my passport.
Yes, you can. I think you've asked me this question on WhatsApp. Yes, you can. Okay. Yes, you can.
Right. Okay, let me look at it this way. For instance, if you were given a 6 month visa and it expires, say, in January, and you did not travel from the beginning, but waited till December and traveled, do you still have a valid visa in you?
Oh, yes. The visa is not expired until it's expired. Once it's not expired, you can always travel.
All right. So once it's not expired, you can always travel with that visa. Keep it coming through. Douglas says, do I need to write English test if I have a master's degree from Ghana to satisfy the English requirement for Britain's citizenship?
No, but you have to do something. You need to have your certificate accepted by the ACTIS, previously NARIC. They have to do an assessment. You need to get a letter from the university to say that the degree was taught in English. Sometimes they do the checks themselves. You will have to upload it on ACTIS platform. You pay a small fee. They will do it. They will give you a certificate. The certificate, together with your master's degree, will then exempt you from just the English language, but you have to do the life
Like in the UK. Well, that's obvious. You're coming to live in the community, so you would have to make sure, or they will have to make sure that you fit into that community, and you need to know about the community, obviously. Okay. Well, Akaben, the other bit that I want us to look at, because it's a conundrum that's really um, baffling so many people. I know some countries have issued letters to their citizens to say that from January, when you come into the UK or you're living in the UK, you're going to have your e-visa account. And e-visa account, well, Home Office has stopped issuing BRPs. And any BRP in the system is ending or expiring on the 31st of December 2024. So from the 1st of January 2025, things are going to change. We are all going digital. Well, are people getting it right?
No.
What's happening? What's the main thing that people are getting wrong?
Because we are not taking it seriously. And I have to put on my community spirited hat. Now, when somebody dies, you see all the community pulled together, and some people who are couples in the community will then come on TV and radio and say, oh, this person was stabbed, this way. Why are we not doing it? Why are the churches not putting out tables after church to help people to do the e-visa for them? Why are churches not leading this? Where's the Ghana Union? Where's the Ghanaian communities? Why are they not announced? I'm not saying bring me on. No, this is not for me to come and do. You should be able to say that announcement. Yes,
People have to do that.
This.
It's going to affect everybody.
The number of times people are not aware of what is going on, and they are living in Ghana, and they've got wet ink, and some of them have no time to remain. Vignette or paper stamp. My concern, please, I'm not saying don't go and enjoy your holiday.
A friend who's come on, please hold on. I'll come with you.
What I'm saying to you is that the people who call themselves community leaders, our churches, our pastors, our reverend ministers, if they are doing it, I haven't seen them do it. They're not doing it. And it worries me because we are a community. I did say to you or someone else that the Home Office provided 50 million.
No, it was me.
It was to communities.
And we missed out. We didn't take them.
Yeah. Please. You know the way I am. I associate with people who are forward-looking, and that's has been my life. Why are we not helping the community? There are people who don't watch this, who don't have modern phones, who will not know, they can't read and write. They've got their passport. They've got 4 passports. The visa is in the first one, second one, third one. He travels, he comes quickly, his work for the same business for 25 years. He doesn't even want to know. When he hears immigration, he doesn't be okay. I'm okay. I don't have any immigration, so I don't want to watch. This is the time for our churches, our community, and I keep saying churches because a lot of
people go to church.
Yeah. So on Sunday after church, or even one of the weekdays, the church should say that if you are a migrant in the UK, whether you're a church member or not, we've set up 4 tables here. We've trained people to help you to do your e-visa. Let's do it for them for free. We've offered over 6, 7, 8 months ago. Every week people come here, we do it for them. There are other things that I've done a video which will come out. There are other things that you should be doing as well, which will allow you to travel in and out so that you don't have to use your card anymore. But I'm saying that the number of people whom are not doing this e-visa is more than those who are doing it.
Procrastination is a thief of time, and I believe this is where we're finding ourselves now. Please do it because the 31st of December is not far away. Those of you who would have applied for BRPs after October would realize that they're not giving you a card anymore. I think it's just a letter that's coming. And Ade, let's put that lecture on. So I'll get Ankaben to go through for us. When you apply for a BRP, this is a letter that comes in. So you ask yourself, why? I'm waiting for my card. They won't give you a card anymore. Your card won't come. It won't happen because now we are all going e-visa. And about this letter, what does it do? Is it just a letter they tell you and they leave your life for you to, they leave you to go wander?
Okay, so Kweku, from the 1st of November this year, nobody will receive a BRP or a BRC. What you receive is this letter. And let's look at what the letter says. So we know that this person has been granted 10-year route to settlement. We know that they can stay up to 2027. We also know that to prove your immigration status, they have to do something. What does it say?
Proving your immigration status, you can keep this written notice for your personal record. You should now create a UK Visas and Immigration, a UKVI account to enable you to access your e-visa and prove your immigration status, your permission to stay, information on how, your permission to stay, full stop. Information on how to do this in the next steps section. Your conditions, your study conditions, and all those bits. You go up. Yeah. So let's go to the next steps. Yes. So it says that, I'll read through this quickly, and Uncle Ben, as always, try to break it down for us, and I would crave his indulgence to do that again for us today. We are replacing physical documents such as biometric resident permits and vignette stickers with an online record of your immigration status. This is known as an e-visa. What do you need to do now? You must create a UKVI account to access your e-visa. Use the following link to create a UKVI account, and that is www.gov.uk/get-access e-visa. Now, to create a UKVI account and access your e-visa, you need your date of birth, your BRP number, or unique application number, UAN. Your UAN is at the top of this notice. This has been taken care of, taken away because it's somebody's personal one, so we didn't have to do that. Let's go back to that. So by when you receive a letter, it will be on the top right. Your passport, if you do not have a BRP. Now, let me ask, even if you have a BRP and your passport, can you use either of them to create the e-visa account?
So there's something new happening. So this person, the Home Office has created the e-visa. So the e-visa is in the sky or it's in the cloud. Okay? Be careful. If you are Ashanti like me, you might say crowd. It's called cloud. So it's in the cloud.
Okay.
And because it's in the cloud, they want you to take steps
to bring it down.
So that you can access it. They can see, because they haven't given you a BRP. The BRP that they should have given you, they've put it in the cloud.
Go and pick it up.
So they want you to go and pick it up. And they didn't just tell you to go and pick it up. They've shown you the steps to go and pick it up. So you have to follow the steps. And the steps, they've told you several things. I want us to go back to the letter. Ada, let's go back. Go after this. No, next steps.
Next steps.
Let's go. Stop there. Have you seen access to an email address and phone number and access to a smartphone?
Yeah.
Please, if you've got a YAM phone, that's why I keep saying, where are our churches and our community groups? Because some people have YAM phone. Some people's phone cannot download the app. And that is why we have offered to do it for people for free. If you come, we'll do it for you. Because we are aware that after December, this will be a big problem. And the least that we can do for the community is offer our services, our time, and everything. But if you don't have an email, you need to create one.
Okay.
If you don't have a phone, you need to create one. If you don't have a smartphone, don't go and buy a smartphone. Please, when you go to church Sunday, tell your pastor that Uncle Ben said that
I should use pastor's phone.
pastor should now put a table out after church or a time suitable for all of us who don't have smartphones, cannot read and write, to come to church and have this. Tell them that Uncle Ben said. The pastor will understand. I know some of them will text me. We'll have a conversation. But above all jokes aside, if you don't do this, today when I was coming here, I got a call. Someone is going to Ghana. They've lost their BRP. If they had an e-visa, all they need to do is to show the e-visa, even to the British High Commission. And that's it.
That's it.
They can see, oh, you're the same person. The same person. Let me see. I've done a video. It might solve some problem. It might not solve it. You can see that we've put a lot of time and emphasis on this because what we want to do is for the community not to be left out in this. You must please understand that from December, after December 31st, just like the Brexit, you cannot use your BRP. They've advised everyone to keep hold of their BRP and their passport. Once you've used your BRP, because those people who have the BRP, they don't have this letter. Because this letter, they've already created the e-visa for them. But they have to create an account. The first step to going into the cloud is a UKVI account. And when you create a UKVI, when you scroll down, it will ask you to update your identity documents. That is when you scan your passport and then you use your passport to go in. When you're creating your UKVI account with only a letter, you don't have a BRP, so you have to use your passport.
Okay.
And that passport will be locked in so that when you're coming from Ghana, the things that you have to do after that, they will tell us very soon. The immigration officer in Ghana, the British Airways people in Ghana, it's very likely that you will give them a share code. They will use a share code to go and see your beautiful face in the Zoom. Please, let's be very careful here. If you don't do this, if you come after December, we will charge you because we've given you the opportunity. You didn't take it up.
And there's even a video coming out.
There's a video coming out. We've even done a scan, and I think I'm going to share the scan with Adai. I'm sure that we can share the scan, and people can go and watch the video now. Let's see. Let me see. We should have the scan. Let me see. Where's the scan? I know the scan is somewhere. Ada, you've got a scan, right? Oh, everybody's got a scan. So we will share the scan. Those people who are watching at home can also have a look at it. Yes, there's a scan here. Where is it? Oh, not this one. Well, let's go on. I will share the scan. Don't worry. It was shared yesterday by, on Thursday by Anita. So it will be there. We should all have the scan. And yeah, it's coming. Like I keep saying scan. It's actually QR code. Yeah. I know we should. What's happening? So we've got a QR code now. Now you've got it. I'm sending it to you. Don't worry.
Okay. Let me see.
So we've shared the QR code now. If you put it on the TV, people can watch the video. If you can.
Interestingly, on the TV, you can put your mobile phone there and scan the QR code.
Yeah, so
that's one should be able to.
QR code.
That should be able to. So
yes, it's taking me to the YouTube.
Yeah. So yep.
Did it take you?
Yeah.
It's taking you.
It's taking me there. So on your TV, You can scan the code and it will take you to the Home Office YouTube channel where you can go through how to create the UKVI account and get access to your visa. And this one, Ade, let's get back to the video. Let's get back to our video. This was created 3 months ago.
Yeah. Yeah.
Listen, we go on social media and do all the things that are unnecessary. This is pretty important. Now, you with the QR code that we gave you on the screen, it will take you there. Or we can even copy the link and send it to you by our WhatsApp channel. If you are on our WhatsApp list, we can send it to you in our broadcast. Simple, straightforward. Can we keep the QR code on there again? And those of you who have not been able to do that now, do it now. Even on your mobile phone, you can use another mobile phone and just tap it and it will go. Or switch your camera on, then it would scan it straight away, no matter how far away you are from it. Once your camera can focus on it, it will pick it up and it would say on your screen, there's a yellow bar there that says YouTube. Click on that YouTube and it will take you straight to the Home Office YouTube channel. And it says how to create a UK visa and immigration account and get access to your e-visa. Thank you very much, Prof. Mr. Producer. This is where the information, and you get it from BWF Solicitors. And when, yes, the video. What is the video coming on Monday? I guess. I know. People are so interested in videos. Home Office, they are not friends, but we are friends of BWF Solicitors.
Yeah, the video is, as we do both P and English, because
right.
I realize that our people don't obviously watch those things. But please, let's help those who don't have smartphones, who cannot read and write. Let's help them. I've seen a few people charge. I cannot comment on it. But if you come to us, we'll do it for free. If you come, we'll do your e-visa for you for free, so that you don't come and disturb too much or wait for too long. We always ask that you call and book appointment. But if you're happy to wait, you can pop in and then somebody will see you.
Yeah. So those of you who have been able to scan the QR code, please pick up the link, put it in your WhatsApp broadcast list, and send it out. Listen, Yenya can consent you for at least 1 week. I'm serious. Yenya can consent you for at least 1 week. Yenya the channel DA for at least 1 week, and let's get people to subscribe to this channel and learn. Because even from the 1st of January 2025, if you go and you get a problem and you come there, I will advocate that he charges you twice. Because from August, September, October, November, and we're going into December, he's dedicated time to do this. What else do you want? Anyway, unfortunately, we have, fortunately, I should say, we have a friend who's lived and stayed there for too long. Good afternoon. Hello.
Good afternoon.
Good afternoon. What's your name, please? I'm Chino Bakandi Bodi.
Francesca.
Francesca, okay. Much of a question here. That's so original sort of train. Why? So now what class now TB? Okay, but you into
yeah, Bufan. The question, I'm trying to answer.
Oh, okay.
Or something that
A question.
We call me naturalization. Me person who I mean Yama and my family.
Okay, so you are applying for your naturalization and you think that you met all the requirements. Would there be anything that would prevent you being successful in that application?
Yeah.
Okay,
Yeah.
Uncle Ben.
Yes.
The other question is, But that is also apply for indefinite stay. But on any year end, now or the first one, no to first one, not the year. But home office I'm sending information in here now. But as far as we are concerned, we are sending the at their mom. But almost on only one and but only link only open it. But nipa no so man no dan and kana kaka no cancel house no di dan na man then so very anything.
Okay. Well, into response, right?
Well, we English, me sure some make before, but because British citizenship, I was say what to do from make up before. So two questions were asked. One I've answered already, but I'll repeat it. When you apply for British citizenship, there are several requirements, some of which is a suitability requirement or character requirement. So you don't have any criminal convictions or outstanding penalties. Bankruptcy has been discharged. Residential requirements, if it's under your own application, then it's you've lived here lawfully for 5 years and you had the indefinite 1 year goal. If you're married to British, then 3 years lawful residence, there's no need to wait after 1 year when you get your indefinite leave. The second one, I think, I better say the Panama frame. Na Yeden Akasa. Why?
But you
Okay.
Okay. All right. Thank you very much. Just realized that we've run out of time. The linking or updating of the e-visa, where you link your passport to that and you get the process completed.
Yeah.
I think that's where a lot of people have issues. Can you quickly take us through what needs to be done?
Okay, so to create the UK VI account, you need to have a biometric residence card or your last application reference number. If you don't have a BR card, you've misplaced the BRP card. You can use the last application reference number. You use the reference number as the code. So they will ask you, were you granted status before or after the 1st of November? Now, if you're going to use the code would normally be after, okay? And then if you've got everybody who has a BRP card can open it. You then use the first one because you got your status before 1st November. You go in there, you use your card, it will send you a text message because you'll be asked to put your mobile number, your email. It will send you an email to verify your email. Once you've done that, you would have opened the account. Once the account is opened, you haven't finished. The process now starts. The system will identify your BRP with a status on it. But to put you as the owner of that, you need to scan your face and take a picture. Okay. You cannot scan your face if what is on your phone or on the computer has not been downloaded on a QR code. Yeah. So the QR code you scan, it will take you straight to an app. The app will then ask you questions and give you instructions. Take the back of your card, not the front. It starts with the back. The back, yeah. Take the front. Once you've done that, don't press scan, please. Put your phone on the card first. Once the phone is on there, press scan. If you press scan before you put your phone on the card, it won't scan. It scans, it will then say scan your face, please. Don't scan your face in the background like what we've got. It should be cream or burgundy or white. Now, you stand there, you scan your face. And this is where my sisters, my nieces, my mothers...
I know what you're driving at.
Yes.
Eyelashes and the makeups.
Because the makeup is not much of a problem. It's the eyelashes. Because the scanning is taking an imprint or a copy or a print of your facials, critically your iris, when you go here. So if you put on those blinkers which have covered your eyeballs,
You won't see it.
it's not going to see it. So when you call, last Monday, we had two ladies who came here. They both had it, so they went to the bathroom and washed it. And they were complaining, oh, money I told myself, why do you even put this? Because for me, it hasn't got any aesthetics to it. Anyway, make sure that you scan your face, you take your picture, then you log in again. Once you log in, you'll be asked to confirm your identity. You press on it, it will scan, and because it's taking all those features, it will confirm. Then residence, you will confirm. Then security question. So there are questions that you must put. If you're very forgetful, just they will ask you, where did you go to your first primary school or your first school? Where were you born? Where was your father born? Me, I'll put Accra, Accra, Accra. You know why? When your system is locked or you've forgotten your password or something and you call them, they will ask you one of the security questions. And if you've you've put in Rara Primary School, and then you remember that no, you didn't go to Rara, but you went to Gomoafa in Chenekot Primary School, and you tell them Gomo, they will lock the system. They won't give it to you. And that's what I'm saying, that you can put Accra, 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 Kumasi, 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 or whatever takes your fancy. Once you've done that, you will get an email to say your e-visa has been created, your reference number is 3434, and then you keep it. After a while, they will email you that your e-visa has been created. Those people who get their residence after 1st of November, your e-visa is already created. So you need to create an account to go. Please, don't go and tell people that I said the e-visa is created if they were given stay after 1st of November, so they shouldn't do anything. They have to go and claim it.
Yeah.
And then you link it, and you can see it's there. You can update your address. You can upload your passport. You upload your passport through the UKVI account, not the e-visa. Your UKVI account. When you move address, you have to change it. If you change your passport, you have to upload a new one. They will then approve it and link it, and that's the only way you can travel in and out from January next year.
Okay. So if I hold a EU passport, but I've done my EU settlement scheme and I've changed my passport, I will have to go on there and update my current passport.
Yeah. So if you are EU national dependent, EU family member, you've already got an e-visa. You may have created the portal with your biometric card. Go back and add your passport. If you've got a new passport, log in and update the document section and add your new passport. That way you don't have a problem. EU nationals, you don't need to go and do the things that I've said, the e-visa thing. If you do it, they will lock your card. And when they lock the card, I cannot open it because I haven't got a key to open it. You have to call them for them to open it for you.
Okay. Well. I wish we had more time to do some of these things. But listen, before the end of the year, we would have the opportunity of going through this again. And maybe, if you don't mind, we could use your card at one point to set up the account for you if you so give the consent, so that you know you're doing it right. But in any case, BWF Solicitors has offered to do this for you before the end of the year. Book an appointment, come in, and they do it free of charge. But to our community groups, churches, associations, and all that, before you do your Christmas parties, listen, ask people to come to that desk before they register to even participate in the event. Do their thing for them, because everybody needs help. And that's why we are the community. Earlier on, they offered to give money for this. We didn't go for the money, and now we can't let our people suffer. So do that as much as you can. And that's, I would say, if you have any doubt, 0208 493 7340 is a telephone number of BWF Solicitors. This afternoon, we have had a discussion on sole responsibility and the skilled worker route, how to avoid the trap of sole responsibilities, what we discussed, and the senior partner of BWF Solicitors, Uncle Ben, was here. I'll give him the opportunity to just do a quick sum of what we have done before we say our thank yous. I know we've run out of time, but listen, it's been worth it. Uncle Ben.
Okay, so what we've learned today, we've learned that when you're here as a skilled worker, if you're making a child application to join you and there's an issue of sole responsibility, there are basic things that you need to do. You need to collect the evidence of the school, the hospital, the church, and add it. You need to cross-reference that with the Home Office requirement. You need to go back to your roots and then give a story of how your child was born, all the things you've done for the child. You can pick milestones, maybe when they were started crawling, everything. You write a story and show exactly how you directed and controlled your child up until the time you left. And whilst you're here, you still control and direct the child by speaking to whoever is looking after the child and speaking to the child. In addition, make a human rights claim as part of the application. Say why there's a human rights claim because of family life with a child under 18. That's the default position. Refer them to what a human rights claim is. Refer them to Section 55. Refer them to the guidance. The latest one is 11th of October. And then say that you, in addition to the application, you have made a human rights application, which will attract a right of appeal under Section 82 of NIAA 2002. I hope you'll be able to do it. But please, if you can't, speak to a lawyer. We are here to help. But there are many lawyers as well who will be able to help you. And hopefully, if you do this right, even if they refuse it, you have a better chance of challenging it than just going to collect consent from the other parent who is not required to give consent.
Need I say more? The senior partner himself said everything and offered you the route for help as well. I have just done something and I would want you to do the same. I've copied the how to create a UK visa immigration account on my WhatsApp status. Please do that. At least for the next 24 hours, we'll have a lot of people looking at that. But in any case, you are giving a blanket invitation to come join us again for another edition of The Community and the Law, which is brought to you by BWF Solicitors. So to Uncle Ben, thank you very much for your time, your effort, and of course, the share of knowledge to the family of BWF Solicitors, both here in the UK and in Ghana. We say thank you so very much. Congratulations and happy birthday to you, Lawyer Annie. And also to Sheila and Mododu for the admin and aesthetics, to my studio producer, Professor Ade. Thank you so very much. Unfortunately, we couldn't do. Yes, yes. I think before I go, I just been prompted. I was probably going to skip that. Now I put the question out. Can we just quickly look at that and see how many people were able to crack it? Nana Kwadwo works 3 days in a week, equivalent to 24 hours in a week. Applying the working time regulations, how many days of paid holidays is Nana entitled to a year? Charles is number 3, 16.8 days. Clement Ahimsa Bonzikwe says number 2. The answer is 2 because oh, it's picked up something wrong. Yeah. But look at that. Let's see what the answer would be. Let's go to Esther Usua says number 2, that is 10.8 days. Yvonne Asante says number 1. So we've got 1, we've got 2, we've got 3. One of them is correct. Aaron Inning, number 3, 16.8 days. Rights upon number 3, 16.8 days. Priscilla Kwachi, number 8, 16.8 days. Remember, works 3 days a week, equivalent to 24 hours in a week. So each day, how many hours that she work, and what number of days would Nana Kwadwo be entitled to holidays in the year? What's the answer? Uncle Ben.
Well, so we have to do board mass. Board mass. So
bracket first.
Yeah, bracket. So you do X times 5. The maximum days holidays you can get in a typical week is 5 days. If you work 7 days, you only get 5 days. So board mass, we put the bracket. X is what? We know X because X is a variable.
Okay.
How many days does it work?
3.
3 days. Divided by 5.
By 5. Then
times 28, because the 28 days is the maximum number of days you can get. And the answer is 16.8 days.
Those of you who got this correct, did you guess? Or what did you do? Anyway, the formula for part-time employee, as Uncle Ben says, is holiday entitlement, which is equal to hours worked per week times the 5.6 weeks. Nana is a part-time employee and he works 3 days in a week, equivalent to 24 hours. So 3 days divided by 5 times the 28 days, which is 16.8 days. And that's from the Working Time Regulation of 1998. Prof, I think we will compile those who got it right, and I'll give them a prize when we do the Senior Partners Appreciation. So those of you who got your answers right on the 16th of November 2024, the deadline is now. So if you add anything after, I'm not going to give you that. But those who got it correct, I'll acknowledge you and give you a present for that. Well, with that, we want to say we come to the end of another wonderful edition of the Community and the Law. Once again, my name is 𝗖𝗢𝗠𝗠𝗨𝗡𝗜𝗧𝗬. Thank you very much. Have a good evening.